Hey everybody, the Irish Demon here, back with another video. We have a Sovsid in court today challenging the jurisdiction of this court, and the judge puts him in his place pretty quickly. Now, she gives him a lot of opportunities, probably more than I would if I was a judge, but what do I know? I'm just a guy on the internet. But I actually was going to cover this guy the other day. I had it recorded, ready to go, and then a load of stuff came up and I didn't get a chance to do it. But basically, he's asking if it's Admiralty Court, the usual Sovsit nonsense. I'm going to let the video play for you. You let me know what you think down below. And you can comment as you're going along and, fill in any gaps that you want to. And we'll catch you at the end of the video. And now, just before we get into the video, I want to give a massive shout out to my good friend, Colin, definitely not Cromwell, who texted me and let me know that this was going on right now. You can check out his channel down below. He'll be covering this as well. So anyway, on with the video.
I'm not sure if we're waiting for the prosecutor, but on Mr. Michaud's behalf, I would say that I'm not sure if Mr. Michaud wants me to continue to represent him. I think he's expressed previously that he does not want me to continue to represent him. I'm happy to be here as some sort of standby counsel, but I prefer that Mr. Michaud sort of speak to whether I'm representing him or whether he intends to represent himself.
Give me one moment so we may get the prosecutor's appearance.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Thank you. And Mr. Michaud, your name for the record, sir.
I am the beneficiary of the Frank Anthony Michaud Jr. estate, making a special appearance, not general, and I appoint you as my trustee for the record.
And Mr. Michaud, were you able to hear Mr. Sullivan indicate that he is standing by as shadow counsel?
I heard him.
Okay. This case is scheduled this morning for PCC. How are we proceeding?
I'm here challenging the jurisdiction for the record, ma'am.
Judge, the people are prepared to set a preliminary exam in regards to this matter.
Mr. Michaud, you're able to raise that at the exam date, the allegations that these events occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you ready to have the exam scheduled, sir?
I'm not here to
Mr.
have an
Michaud?
exam. Still trying to wonder why we moving forward with even having an exam, especially after not having, by the due process, even having a probable cause hearing.
It's not a problem, it's probable cause conference, sir, at which time the parties will indicate if they're ready to proceed to exam, if there's a plea or a waiver or some other resolution. So at this time, the assisting prosecuting attorney has requested that an exam be set. Are you prepared to have the exam scheduled?
No, as me here challenging the jurisdiction for the record, I want to put on the record that once the jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That's Mello versus US for the record.
And sir, what is it that you find, what is your allegation regarding the jurisdiction?
Well, what is the jurisdiction that the court is operating up under, ma'am? The Sixth Amendment.
The court has already,
the right
Mr. Michaud, the court has already indicated that the allegation is that this event occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you indicating that this event that brings us here to court did not occur in the city of Romulus?
Well, I would like to know what jurisdiction is this court operating up under so that I can properly defend myself and represent myself for the record. So the Sixth Amendment granted me the right to know the nature and causes of these actions. So I would like to know what jurisdiction are you operating up under?
Sir, what the file indicates is that there's an offense dated February 23rd, 2021. And again, that the case happened at Detroit Metro Airport, which is located in the city of Romulus. That is a jurisdiction within this court's parameters. So that being the case, would you like to have an exam scheduled?
No, I would like to have, under what jurisdiction are you proceeding with so I can properly defend myself? Under what
I've said
jurisdiction?
I've said it 3 times already, Mr. Michaud.
You-
If you have indications or information that
you-
the
you gave
event
me-
as alleged did not occur in the city of Romulus, I'll hear it at the exam date.
That's not a jurisdiction. The jurisdiction has to either be one or two. Is this common law or amity jurisdiction, or is, for the record? You gave me a location.
Michaud?
A jurisdiction.
Mr. Michaud, respectfully, what we'll do this morning is either schedule an exam, adjourn the PCC, or waive the exam. One of those 3 things.
Well, the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. That's Higgins versus Levine. So I still would like to know under what jurisdiction so that I can properly defend myself, not the location. I need to know what jurisdiction is this court operating up under.
Mr.
It wouldn't
Michaud,
be a violation of your oath of office to tell me.
Mr. Michaud, for probable cause conference, and I'm sure that you've heard this before, we're doing one of a few things. We are scheduling the exam, we're adjourning the PCC, or we're waiving the exam. How are we proceeding?
We can't proceed until jurisdiction is proven on a record so that I can fully have an understanding of what's going on. I still don't understand what is going on without jurisdiction being proven on the record.
What don't you understand, sir?
I don't understand what jurisdiction are you operating up under. I have the right to know. And are you denying me my right to know what jurisdiction are you operating up under? Because it is your constitutional oath to let me know what jurisdiction it is that you are operating up under. And you still have not yet
This is the
given me my right.
This is the 34th District Court, Mr. Michaud.
That's not a jurisdiction. That's not a constitutional jurisdiction, ma'am. Is this common law or amity? Is this criminal or civil?
It's a criminal case, sir.
Okay, if this
It's
is
a criminal case where it's alleged that you were a felon in possession of a firearm and that you carried a concealed weapon, that's count 2, and then count 3, felony firearm. Those are the allegations. I've given you the 3 counts in this matter. I've given you the date of the offense, and I've given you the location of the offense. We
But
can
you
do one of
haven't-
3 things this morning, sir. We can adjourn the PCC, we can schedule the exam, or you may waive the exam. Which would you like to do this morning?
I want to have my rights given to me, and my right is to have the jurisdiction of the court. That's just for the record.
I've already indicated to you, sir, what the court is.
Is this common law or amity? That's the only jurisdictions that we can, that I know of. You still haven't acknowledged neither one, and I still don't understand what's going on. Until you acknowledge one or the
Yes.
other, we still haven't got jurisdiction on the record.
Mr. Michaud, do you intend to represent yourself in this matter going forward?
I would like to know jurisdiction so I can properly proceed to present myself properly. I can't properly present myself or defend myself without knowing what jurisdiction that you're operating up under. And you said it was criminal, so if it's criminal, then for a crime to exist, there must be an injured party, a corpus delicti. There can be no sanction imposed or penalty imposed on one because of this constitutional right. So if this is a criminal, where is the injured party? Who have I injured? I have the right to face my accuser, face the one who is bringing these allegations against me, ma'am.
Mr. Michaud, if you wish to be able to defend yourself and hear witnesses against you, the court is happy to schedule the exam. Is that what you're asking this morning?
No, as I appointed you as my trustee, I demand that you dismiss these actions for no corpus delicti, no proper jurisdiction, for no proper crime, injured party.
Mr. Muhammad, your response to Mr. Michaud's request that this case be dismissed.
Judge, the people's position is we would object to dismissing this case on the basis of lack of jurisdiction. As you mentioned earlier, this crime did occur in the county of Wayne, and thus we do have jurisdiction.
There is no jurisdiction without an injured party, for the record. So I would like to face the injured party for the record.
And Judge, my
Yes,
response is, then we should
Yes, sir.
then I believe we should set this for a preliminary exam.
I object to that, ma'am. You cannot proceed without jurisdiction being provided on the record. And you being my trustee, for the record, ma'am, you have to dismiss this case as I demand for the record.
Your request to have this matter dismissed is denied. Mr. Michaud, my question will remain the same. Would you wish the court to schedule an exam? Do you wish to waive that exam and have your case bound over to Third Circuit Court, Frank Murphy Hall of Justice? Or do you wish to adjourn the PCC? Those are your options this morning, sir. They're going to stay the same.
I would like for jurisdiction to be provided for the record, and that if not, I demand dismissal for the record.
This case will not be dismissed, sir. Would you like the exam scheduled? Would you like to waive the exam, or would you like to adjourn the PCC?
Again, jurisdiction for the record. You cannot proceed without, when once jurisdiction is challenged, again, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That is Mello versus US.
Mr. Michaud, this is the last time that I will say this. I've indicated to you that this court is the 34th District Court, that this case is criminal in nature, and the allegations that it occurred at Detroit Metro Airport, which is located in the city of Romulus. If there's something you wish to present, you may do so at the exam. You may present your motions at the exam date. So do you want an exam? Would you like the case to be waived? Or would you like to adjourn the PCC to confer with Mr. Sullivan?
No, I would like for this case to just be dismissed because the lack of providing a proper jurisdiction would make it seem like there is some secret jurisdiction being held against me without me knowing, and I don't consent to any jurisdiction that you have presented. I reserve all my rights for the record.
Understood. And that being the case, Mr. Sullivan, is there anything you'd like to add, sir?
Judge, I don't know what to say. I'm not sure that I still have authority to represent Mr. Michaud. I will say that Mr. Michaud has made his arguments, a couple times, and I think that the arguments have been, or the motions have been denied. And I've explained to him that those motions, his arguments are preserved on the record, and that he maintains the ability to appeal any denial of his motion to dismiss. He would be able to appeal that first at the circuit court level and then up to the Court of Appeals. So I've done my best to advise him of his rights to continue making that argument. I will also, I think the court may already be aware that Mr. Michaud is not in custody on this case. He's in custody on a contempt of court that Judge Oakley sentenced him to back at the end of January. So I don't know that there is, unlike clients that are in custody, a reason to expedite the setting of the preliminary exam. So I really, I want to defer to Mr. Michaud's stated interest, what it is that he wants to do with this case. I've given him advice, and I don't know what I can do beyond that. Again, I don't want to create any conflict in my representation.
Mr. Sullivan, the court wasn't asking you to. The court has heard Mr. Michaud's arguments. The record has been made. Your statements have been preserved, Mr. Michaud. And at this time, the court can do one of two things. We can schedule you for an exam next week. We have space available next Wednesday, the 28th. We can adjourn this matter for another PCC next Wednesday morning at 8:30, or you may waive your exam. Your response is one of those three things, please, sir.
Well, my response, I want to ask you a question. Are you honoring your oath to the Constitution today?
Yes, sir.
Okay, and I accept your oath, and upon you honor your oath.
Then Mr. Michaud, no. I've answered your question. I've now given you your options multiple times. The court has other cases. Are we scheduling an exam for next Wednesday? Are you waiving your right to have the exam? Or would you like another PCC next Wednesday morning at 8:30 so you have time to consider your options and how you will proceed in this case?
I demand a dismissal for lack of jurisdiction for the record.
Your request is denied, sir. The record's preserved. If you wish to appeal that decision, you may do so in writing properly filed. Again, exam, waiver, or adjourn PCC.
Dismissal for the record. I demand that you dismiss this for not, you cannot move. Once jurisdiction is challenged, the court cannot proceed for the record, ma'am.
And Judge, for the record, the people would like to request a preliminary exam. There will be no plea offer. We did already have a probable cause conference in this case, so we are prepared to move forward, Judge, just for the record.
Mary Ann, is there space next Wednesday afternoon?
Yes, Judge, at 2:30.
I object. Court cannot proceed without jurisdiction for the record. Jurisdiction has not been provided for the record so that I may.
Mr. Michaud, the court has responded and provided the appropriate information to you. The exam will be scheduled for next Wednesday, February 28, 2024, 2:30 p.m. in person here in courtroom number 1. If there is a motion that you want the court to consider, the court will take it up as a preliminary part of the exam.
I object.
Anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Michaud?
I demand for a dismissal for the record. Court cannot proceed without jurisdiction being provided for the record, and yet you still continue.
Your oral motion having been heard and denied. Anything else?
Why are you denying to put the jurisdiction on the record? Why? I just want to know why. Why are you denying?
I've done that, Mr. Michaud. I've done that. I've asked you multiple times how you would like to proceed with this conference. You refuse to answer the court's question regarding how we're proceeding. The prosecution has requested an exam. The court has scheduled an exam. If there are things that you wish to take up preliminary next Wednesday, we will take it up before the exam starts.
I'm not prepared. Do not wish to have a preliminary without me knowing how to defend myself under which jurisdiction. So it's still a violation of my rights, my due process. You're moving forward without telling me which jurisdiction so that I can properly defend myself and represent. Civil and criminal procedures have different jurisdictions, and I need to know which one are you operating up under now. How could you?
You do, Mr. Michaud. The court's answered the question multiple times, and the court deems this matter concluded. I will see you next Wednesday afternoon.
Check to that.
Your Honor, ma'am. Just for the record, his out date right now is February 24th. And if your clerk can send over paperwork, that way we have this case, this date and everything in the computer.
Understood, Marianne. We'll take care of it. Thank you.
Hey everybody, today we're going to be having a look at a more sovereign citizen in court by the name of Amitai Bey. Now it's probably not a good idea to show up in a court Zoom call while breaking the law.
And sir, you are Amitai Bey, is that correct, sir?
Yeah, Amitai Bey, real party interest in this matter.
Okay, are you driving a vehicle right now while you're on the hearing?
You said I'm driving a vehicle. Yeah, you need me to stop? I mean,
I need you to stop, sir. I can't have you driving
give me
while
15
you're.
seconds. I can pull it back up to my family house, and I'll stop.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Jan. Y'all can get out for a second. I'll call y'all when I get back.
Okay, this matter is scheduled for a hearing.
Yes, they are his small children in the back of the car that he's driving while looking at a phone during a court Zoom call. Way to go, Galaxy Brain.
And do you recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
And
Objection, Jan, and hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly.
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, It seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I would disagree as tremendous. So,
Okay.
court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
All right, your objection is part of the record, sir. All right, you may continue, Mr. Dewhurst.
The judge was basically like, oh, you got an objection. Real cute. Carry on, please.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
Objection, Your Honor. Can he vow to that under penalty of perjury? That's the original document.
Why, yes, Your Honor. Can he vow to that under penalty and perjury?
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature?
Oh, back up the truck here a sec, bucko. Oh, wait, you're Savsit, right? So I should say, travel in a reverse direction in your land ship. First you said
Penalty and perjury.
and now within 30 seconds it's changed to this.
Penalty and perjury.
So which is it? Is it penalty and perjury? Or is it Benelin and Burgundy?
Penalty and perjury.
All right, sir, that's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Sorry for interrupting, Judge. But did you just say penalty and Burgundy now?
Penalty and perjury.
Dude, make up your mind. It's been 35 seconds. What I want you to do is leave a comment down below with your best version of penalties and perjury. And Mrs. Demon's going to pick the best one and pin it to the top. Under specialties in surgery.
You can make an objection, but once you've stated your objection, you have to stop. Okay?
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be
Yes, sir.
expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
if you stop speaking when I'm speaking, then I will state my grounds. And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as a deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
As a government record and or document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
firsthand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, We done reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they are real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Jackson, can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overrule the objection.
Now, as you might be able to tell, this guy obviously looked up court-type words on the internet. And it seems like he didn't really read much past objection, Your Honor. So as you can probably guess, this is going to be a bit of a theme.
Yeah, the property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that I got the taxes in my name? I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Honor,
he said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
This being a non-jury civil trial, the judge will decide what's credible or not. So that's not a valid objection.
I'm sorry. This is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right. Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection,
Okay.
Your Honor.
24 seconds. He lasted 24 seconds without launching another objection.
Was
Rachel Brown and Matthew Brown not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst. Is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
This right here is exactly why I cannot take auditors and SOBSIT seriously. He's trying to set the stage for a fraud trial. And as he stated, there is no statute of limitations for fraud. So the guy better not lie under penalty of purgandity.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay. So this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to you, to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown, that they're yet to respond from? My notary sent it. The notary republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
No, Your Honor, I'm not aware of it.
But that's an argument. That's not a question. This is a time for questions.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
under
sure.
penalty and perjury. Do the company have it, Mr. Dewhurst?
So now we're back to penalty and perjury again.
So you may ask another question.
And okay, also, for you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all gap procedures with this process?
Objection, Your Honor.
Understandable. So I guess the last question, again, I just want him to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Objection, Your Honor. Asked and answered.
No, that's not asking and answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if Your Honor or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
All right.
You're going to let your counsel deal with what? Can your counsel travel back in time? The judge just told you that he wasn't going to put this off for another day. So you and your counsel are too late.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
And if not, I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bey claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession.
Now pause the video and comment down below. Who do you think the judge is going to side with in this matter? The people who have all the evidence that they have a right to possess the property, or the guy sitting in a car saying objection 40 times, talking about penalty and perjury, and having absolutely no evidence whatsoever to suggest that he has any claim to that property whatsoever?
So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bey and all occupants of the premises is granted.
Oh, sorry you lost. There's a surprise.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bey and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction on July 5th, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Well, judging how you performed in this court, I'm sure you'll have absolutely no problem getting a higher court judge to overrule this judge's decision, lest he fall under penalty of perjury.
Okay, all right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor. Have a nice day.
You as well.
So I think it's safe to say that if you're a sovereign citizen and you don't want to retain counsel, then the chances are you're going to lose. Because most of you know absolutely nothing about the law whatsoever. If you did, you wouldn't be sovsits. No matter what some guy told you, or trust me bro, or from the halls of the law courts of Facebook, you're going to lose. Just recently hit a massive milestone on my channel, getting past 20,000, then 21,000 subscribers. I want to thank you all for joining me. If you did like the video and you want to hang around for more, make sure and hit that subscribe button, drop an old like down below, and let me know in the comment section what you thought. Catch you in the next one. Sláinte. So we got a guy here with a fez and the last name Bay, so you just know that that's going to be juicy. Now, I've heard a lot of gibberish in court before, but this is about as good as gibberish gets in these scenarios. How this guy thinks that he's going to get away with any of these really serious charges just because he claims I don't actually know what he's claiming. It's absolutely beyond me. Let me get a good old nickname for this fella.
All right, so Mr. Hensley, I think I see where we're at now. So it looks like court denied a motion to stay proceedings on January 23rd, and then there was an order from the Court of Appeals on January 26th. So 3 days later, it looks like that your claim of appeal was dismissed, and then you filed on February 9th a notice of appeal to the Supreme Court. Trying to find the exact verbiage here of your motion. The motion to stay execution pending appeal of the bond to be waived. Okay, so we can hear that quick then, sir. I do have to go through these series of questions. You probably know them by now as well as I do, but I still have to ask them all. We'll have to go through all of that, sir. So if you raise your right hand, I'll have you sworn, Mr. Hensley Bay. Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
All right, you can put your hand down. All right, Mr. Hensley Bay, as I've noted, we've gone through this several times. I just need to find our list here. But you are appearing here today representing yourself. And is that what you'd like to do today, is to continue to represent yourself on the motion that you have filed asking for a stay of the proceedings?
Yes, I do present myself, yes.
All right, but you wish to continue to represent yourself, is that accurate?
Yes, I continue to present myself, yes.
All right, and then, Mr. Hensley Bay, do you understand that representing yourself can cause you to be at a disadvantage, particularly as it relates to the people who are represented by attorneys? And recognizing that you could be at a disadvantage, you continue to wish to represent yourself. Is that accurate?
Correct.
Okay. And Mr. Hensley Bay, as I mentioned before, that if you wanted to, you could ask for an adjournment. I'd actually grant you that adjournment. If you wanted to hire an attorney, are you waiving your right to go hire an attorney then?
If I need outside counsel, I can get it. Gratitude.
Okay, but you're not requesting an adjournment to go hire an attorney and have them represent you on this motion, are you?
No, I'm not.
All right. And you also understand that if you were eligible, you could petition the court for an attorney at no expense to yourself. Are you waiving the right to request court-appointed counsel?
At this time, yes.
All right. And this, Mr. Hensley Bay, do you understand that if you go forward representing yourself again this morning, as you have in the past, that the court is going to be required to treat you the same as I would any other person appearing before the court, whether attorney or not? Do you understand that?
I do not, but
Well, when you say you do not, we've had that argument before in a motion, right? So you're referring to the idea that you thought that there was a case out there that would suggest the court has to give you a lot of deference or wide latitude because you're representing yourself. Is that accurate?
Yeah. Kearney versus Hand, yes, ma'am, yes.
All right. And then we have debated that in the past. The court has denied that, saying that I don't believe the case stands for that proposition. And then if you go forward today, again, I'm going to have to treat you the same as I will Mr. Butler or any other representative from the people. Do you understand that?
I comprehend, yes.
Okay. And then, Mr. Hensley Babe, again, I'll remind you that the charges that you're facing are serious. Those are 5 years of incarceration. That's a maximum penalty on the carrying a concealed weapon charge. Up to 4 years of incarceration on the assault, felonious assault charge. And then the big one here, this felony firearms, is a charge that carries a maximum penalty of 2 years consecutive with and preceding any term of imprisonment. So again, explaining that you'll have to serve 2 years, no discretion by the court or anybody else. It has to be 2 years before you begin serving any sentence that would be associated with 1 and 2. Do you understand that those are serious penalties and that there are risks by you continuing to represent yourself? Do you understand that?
I comprehend. So the time went up on the charges, or because the last I was heard, it was 2 years. So now one is 5 years?
Count 1 is 5 years. Count 2 is 4 years. And count 3 is the 2 years consecutive to 1 and 2.
I heard nobody.
Same penalty that I've read to you over and over and over.
Yeah. I don't remember the numbers being that large, but okay.
All right, but I have to give them to you again today, like we have, and you still wish to go forward on your own. Is that accurate?
I still present myself.
Very good. Do you understand that as it relates to rules of evidence, court rules, that if you continue to represent yourself, the court will have to hold you to those rules, just as I would any other attorney appearing in the courtroom?
So is that the same as you talking about my constitutional rights when you say the court rules?
Yeah, you certainly have constitutional rights, but as it relates to the court rules, the court will have to hold you to those like I would anybody else, including attorneys. So in other words, I can't give you some wiggle room on deadlines or something like that that might be found in the court rule. I have to hold you to the same rules. Do you understand that?
Mm.
You understand that, Mr. Hudson Bay?
Can you repeat that one more time for me, please?
Sure. I'm going to get Mr. Franklin in a breakout room here while I'm doing that. There we go. I think we got it squared away. All right, so Mr. Hudson Bay, back to the question at hand. Do you understand if you go forward today representing yourself that I have to hold you to the same standard as it relates to court rules or rules of evidence or anything else as I do attorneys? Do you understand that?
I comprehend.
Okay. And knowing that you still wish to go forward on your motion today representing yourself? Do you want to go forward representing yourself today, recognizing the court has to hold you to the same rules?
Yes.
Okay, very good. All right. All right, Mr. Butler, do you believe the court's complied with 6.005?
I do, thank you.
Okay. I do find that again this morning, Mr. Hensley Bay's waiver of his right to counsel and his request to continue to represent himself has been done knowingly, intelligently, and voluntarily. It's unequivocal. And I think the court also can rely on the prior times Mr. Hensley Bay has been in this courtroom. It's been numerous. His answers have always remained the same with his desire to represent himself. He's always acknowledged that if he did need counsel, he would retain counsel, or that he would exercise his right to request court-appointed counsel. The court's also satisfied that it has, again this morning, explained the dangers of self-representation to Mr. Hensley Bay and that he'd be held to the same standards as other members of the bar or other individuals appearing before the court. So I'll allow him to continue with his self-representation. And then Mr. Hensley Bay, you're welcome then, sir, at this time, then to give the court any argument you'd like on your motion here that appears to be a request to hold the proceedings in abeyance, a stay, pending your request for the Supreme Court to look at this matter. What would you like to state in support of your motion, sir?
Excuse me, pain. I'm coming. I'm just gonna read my motion. Defense motion for stay of execution pending appeal and bond to be waived. Come now, Milton Hensley Bay, in aforementioned case with a motion to stay. Defendant move for an order staying execution of or any proceedings to enforce the final dispositions judgment entered in favor of Ione County Prosecutor Kyle Brandon Butler on January 8, 2024, pending disposition of defendant's appeal, which was filed with the Michigan Supreme Court on February 8, 2024. Defendant further moves that as defendant is indigent, no superseded bonds be required by the court, or if one is required, that no sureties be demanded. This motion is based on MCLA 600.2605 on MCR 3.604L. In support thereof, I am writing to request a stay of proceedings pending appeal in the above mentioned case. The purpose of this motion is to prevent irreparable injuries to the defendant appellant if the request stay is denied without causing harm to the appellee or the public interest if the stay is granted. Nature of irreparable harm. The denial of due process during the trial proceeding has resulted in specific irreparable injurious to the defendant appellant. The right to a fair and impartial trial is a fundamental aspect of due process under the Constitution. The denial of a continuance and the subsequent trial proceeding, which precluded critical evidence, have impeded the defendant appellate ability to present a robust defense. Denial of continuance. The defendant appellate motion for a continuance pending discovery was denied. Limiting the time available for adequate trial preparation, this denial directly infringed upon the defendant appellate rights to present a meaningful defense. Trial preclusion of evidence. During the trial, the court's ruling led to the exclusion of critical evidence sought by defendant appellate. This adversely affected the defendant's ability to mount an effective defense and deprive the defendant of a fair and impartial trial. Potential for sentencing before mandate. A particular concern is the risk that the trial judge may issue a sentence before the appellate court can issue a mandate. Such premature sentence would cause irreversible harm to defendant's appellate, as the appeal process may subsequently reveal errors or injustice in the trial proceedings. Lack of harm to appellee and public interest. Absence of harm to appellee. Granting the request state will not cause harm to the appellee. The plaintiff appellee's interest can be protected without jeopardizing the defendant's appellate rights to a fair appeal. Public interest court consideration. Upholding due process rights is the public interest. Ensuring a fair and impartial appeal service and broaden goals of justice. And indigence of defendant. The defendant appellant is indigent and therefore should not be required to post supersede bonds. Conclusion. I formally request that the court grant a stay of proceeding pending appeal and, if necessary, waive the requirements for a superseded bond or, in the alternative, allow the defendant appellant to proceed with surety duty to indigenous. See attached proof for appellate court filing in attached exhibit. Closing. Express appreciation for the court's consideration of the motion and provide contact information for any further communication. Supreme Court case number is pending. I also reserve my right to amend this motion and more grounds to be argued or attendance. Thank you. Yeah.
Okay, Mr. Butler, what's the people's position here?
Thank you, Your Honor. This motion is very similar, not identical to what he had previously filed, so our response will be the same. The only difference is that we have received an order from the Court of Appeals, and that was dated January 26th, in which the Court of Appeals dismissed the defendant's claim for appeal. So then the defendant did file then with the Michigan Supreme Court, and that same day that he filed, the court rejected his filings. So there isn't anything that's currently filed, appropriately filed in either the Court of Appeals or the Michigan Supreme Court at this time that I'm aware of. So we would ask that you then deny the defendant's now second motion for stay.
All right. So it is accurate that the motion before the court today is similar to the one that the court denied back in January 23rd of 2004. At that time, there was a motions filed in the Court of Appeals. It was the court's belief that they were premature at that time. And then a January 26th order from the Court of Appeals dismissing those orders or that request for review as not being right in essence. And then Mr. Hensley Bay has filed something with the Michigan Supreme Court. I don't know what the status of that is. The prosecutor has been, hold on, sir, let me finish, and then I'll let you say what you want. And prosecutor suggested that those filings were not accepted. I don't see anything in the file, whether they have or haven't, and it does not impact the court's decision, regardless of what's going on here today. But if I could, in a thumbnail, identify the appeal that the request for stay that Mr. Hensley Bay filed earlier. this one today, are his attempt to have appellate review of different trial court decisions that were made during trial. And that review, again, I don't think is appropriate for any appellate court until there's a final judgment, meaning sentencing. We haven't got that far yet because of these motions. So again, I don't believe that there is any legal justification, a court rule that would suggest that the court is required to grant a stay. Court is not going to grant a stay for all the reasons I've stated on the record here, and that in essence, what Mr. Hensley Bay is attempting to have reviewed is something that can only occur after we have a final judgment, which is sentencing. And then the entire record of the trial, and motions and anything that occurred prior to that date can be reviewed then. And he'd have a appeal of right, as I've mentioned in the past, because of the verdict after trial. So it wouldn't even be the lesser request of a claim of appeal. I'm sorry, seeking leave to appeal. He'll have a right to review of the trial and all decisions that went into it. So respectfully, Mr. Hensley Bay, I'm going to deny the request for a stay here today. Mr. Butler, I'd ask that your office prepare an order indicating the same, and let's make sure so that it's easy to track, or as best we can, that the language that Mr. Hensley Bay has used is in that order. It's denying his defense motion for stay of execution pending appeal, bond to be waived. All right, that was filed on February 9th. And then Mr. Hensley Bay has promised, so I'm denying the stay, but do you have a question?
Yeah, I mean, the only reason why the appellate court, one of the reasons why they denied the motion, because I don't have the transcripts yet. And I don't have any information saying that the Michigan Supreme Court denied anything, because they
Well, that's what I said. I don't have anything either, but
oh,
so here's the thing. I'm denying the request today. Now the Supreme Court, if they sign an order that says, wait, we're granting your request for a stay, then this court has to follow any orders that would come from the appellate courts. I don't have anything in the file that would suggest that.
Okay, but you do have my paperwork that I did file with the Supreme Court, and you have the numbers on everything, the date that I filed.
I have what you have titled Notice of Appeal to the Supreme Court of Michigan, and
Okay.
the case title is TBD, I assume to be determined.
Yes.
So that is in the file. It's received on February 9th.
Yeah, I can't do nothing until I get those transcripts though.
Okay, so next order of business then is Ms. Bond is here. We had a pre-sentence report completed.
No, not yet. He's scheduled for sentencing on March.
Okay, does he have a date that he's to report to?
I'm gonna actually make contact with him this afternoon.
All right. So Mr. Hensley Bay, absent some direction from the appellate courts, it sounds like probation will be contacting you to begin the process of completing the pre-sentence report. And what was our sentencing date?
March 5th.
So March 5th looks like will be our sentencing date. Okay, so make sure you respond to them and get that completed, because I don't want you to be violating the terms of your bond or something of that nature. And I'm not suggesting that you would, because you always appear and you're always polite and respectful. But they're going to be reaching out to you to get that scheduled and get a sentencing date. Okay, sir?
Okay.
Okay, you are free to sign off. Thank you, Mr. Hensley Bay.
All right, I come today and get the order that denial.
I didn't catch that last part. What was that?
That order that he denied, you denied. Can I pick that up?
Mr. Butler's going to prepare that order. I assume that can be done today. I'll sign it, and then it'll be filed at the clerk's office. And you are certainly welcome then to contact the clerk's office for a copy so that you have it for your records.
Okay, gratitude.
Okay, sir, you're all set today. Thank you.
All right.
I got nothing. I really don't know how to even respond to this kind of thing. Again, how he thought he was going to get away with it just because he starts using some fancy words that he pretty much can't pronounce. is absolutely a mystery to me. But let me know what you think down below, folks, and we'll catch you in the next one. Sláinte. Now, one of the best things about being a sovereign citizen is the fact that you don't have to follow any of the rules. Or, well, so they think. And this guy's expressing his sovereign right to not pay rent. He states on his Facebook page that he is the North Moor. So you can kind of see where this is going already. For those of you who don't know, a Moor is a type of sovereign citizen. So when they tell him that he's got to get booted out, he comes up with some very interesting reasons why they simply cannot boot him out.
Miss Black, Jean, do you live in the same residence or are you just here as an interested party?
I'm here as an interested party who would just like to, at some point, enter information into the record.
All right, well, we'll see where we get that far. Miss Foster, this is correct. You want him to move out?
Yes,
All right.
it is a month-to-month lease, so we do not want to renew his lease.
All right. Mr. Black, what's your position?
I would like to know, first off, why. Second off, why Miss Lolita, if she is the actual landlord, why she has not spoken with me. Why, whenever there is an issue, I have to speak with Mrs. McNary. Every issue that has ever came up has been dealt with. I thought to the approval of said person I'm supposed to speak with over this property. I'm funded by Keystone. I've even actually paid cash on top of my Keystone funding. And I would just like to know, what did I do to want to be removed?
Well, first and foremost, the landlord doesn't have to talk to you if they don't want to. It seems in this case that the landlord has an agent or a manager that's looking after it. That's absolutely their right. So that's not going to get you out of this. Number two, just because you're getting Keystone money doesn't mean that they have to continue to rent to you. That's completely aside from any agreement that you've got with the management or with the landlord directly. So that's also not going to help you. Let's see if you can come up with something, bud.
I guess she doesn't have to answer that question.
Okay.
If she wants her property back on a month-to-month lease.
Okay, now
she can ask.
which lease
All right,
is
now
she
just
using
stop.
as this one?
Well, the one
Which
that's
lease?
here.
Now, I got dogs abuse the other day for using the word smug apparently wrongly. Can you all at least agree that this guy's smug, or is about to become smug? Let me ask you this, Judge. Exactly which lease is she using?
Yes, the one that's
Yes,
not
a
my signature and
month-to-month
the
lease.
second lease.
Started February 1st of 2022.
February.
February 1 of 22.
I thought I was out of the shelter right after Christmas. I didn't think I was waiting until February to move. I thought I moved here in January.
Well, that's the date on the lease I'm looking at.
Yeah, well, where's the actual original lease that Keystone has?
I don't know the answer to that. Maybe Keystone has it. Well, anyway, the law says I have to adjourn this for 7 days. So to look into some of these questions, but ultimately, Mr. Black, if a landlord wants to terminate a tenancy on a month-to-month tenancy, they serve the notice to quit. And they let's say the reason is she wants to rent it to her nephew.
Okay.
Or she wants to tear it down and put up a parking lot.
Correct.
Or she thinks you play your music too loud, or she wants to move into it herself. She doesn't have to give you a reason. She just has to go through the steps.
Okay. Can I ask this question? Does that notice to quit have to be filed?
Yeah, it was filed.
It was?
Yeah.
Sure.
Yeah, let's take a look. It was filed on June 7th. She asked you on May 7th to move, and now we're in July.
Okay, so June. Wait. Say that one more time, please.
She
it was
served
filed
the
when?
notice to quit on
She
you
served.
on May 7th.
Served. But when was the notice quit filed?
June 7th.
Okay. Huh?
What, you got something to say? Say it, goddammit.
Yeah, and
All right,
also
I'm
when
gonna
that
continue this
got the
to
letter where my
next.
funding was supposed to be canceled as well, and I
Well, I don't know, Keystone was running out
Yeah.
of money, I do know that.
no, they didn't
How
run
about
out of funding.
August
I got a
12th?
no. Okay, you know what, Mr. Middleton? I got a
At 10
fake letter that my funding was canceled after 4 months, but I know my Sandy, she came into the house visit, and I have 18 months funding, so
Well, you
I
may
wonder
have
if
got 18 months funding, but there may
yeah,
have to
yeah,
be
I
something
know.
other than this.
Did you hear what I
All
said?
right, now,
Okay,
we're gonna continue this.
yes,
I
sir.
told you what your rights were.
Yes,
We're
sir.
continuing it until next week. Now, let's repeat, you had a month-to-month lease in February.
Okay.
So she gave you a notice on May 7th telling you you had to move. You
And that was
didn't
not
move.
filed.
It was filed.
So June,
So
and you
on
said
June,
June
she has
7th.
to wait for 30 days to pass. So you
June?
didn't move. And on June 7th, she filed this termination of tenancy action.
Does the notice
Then
to
we have to
be
schedule it
filed?
for a hearing. Then we have the first hearing and then it gets adjourned for 7 days.
Sir. Yes,
But
sir.
if
You're gonna
she
attack
gets
me on
what she
every
asked
level
for,
possible, all at
Jamal,
once.
you always interrupt me and
Yes,
no
I
matter
do.
what kind of
Yes, I
case we're
do.
doing. I will give you a chance to speak. Let me finish. If she gets what she
Pretty much all
asked
at once.
for, you would have until August 22nd to move out, or you would be subject to being evicted. If you
Okay.
have some defense or other issues that you wish to raise, you can do that next Friday
Okay.
at 10:15
Can I say
in the
who
morning.
is Jamal Black?
Oh, here we go. Release the sovereign citizens. If they can find their own way out, of course.
Can I say that? Who's Jamal Black? Because I don't know who that is. That's not me. So I shouldn't even be at this court proceeding because I don't know who the person that is filed to be the court is. And should I
Well,
take
it's
that
spelled
stipulation? Yes, it's who is that man? It's not me.
JAMALL.
A-L. Who's that? No, no, it's a
All right,
J-A-M-A.
well, that's you. So
It's
be
me?
here next
That's
Friday.
not me. My name is J-A-M-A-A-L-L.
Well, we'll
So
fix.
you're gonna edit something else? Huh.
Yeah.
I'm gonna play
All
hardball
right.
now.
I bet they're scared. You're going to play hardball. But let me ask you this one, Jamal. You claim that the guy on the thing is, and I quote, snot you. So if that's the case, why are you in that guy's house then? Because if it's snot you who's supposed to be in court, then it's also snot you who's supposed to be in that guy's house. Ergo, you are trespassing. Bet you didn't think of that, did you, Savi?
Yes, sir.
Yes, okay, I'll see you next Friday. Gene, I don't know if you have anything to add. We don't smoke in court. But come back next Friday at 10:15. Miss Foster wants him to go. And I don't know what else to say about it. But we'll be
I do
here
have a
next
question,
week.
sir.
Yes, certainly.
So at this point, Jamal has not been evicted. Is that correct? So he should have a key and free access to his room.
He should.
Is that the case? It is not my understanding as of a couple of days ago. Actually, as of yesterday. It's not my
What can
understanding.
tell us about that, Ms. Foster?
He's in his room right now. Yes. I don't
Does he have a
know
key?
if he does not have a key, it's because he's lost it.
All right,
I
we'll
haven't
be
been-
back next Friday to deal with this.
And the lots are not changed.
She's not his lawyer.
All right, so it seems like his mom came in there to try save his skin at the end. I bet that's also not going to work. Here's the thing. If you're a Sovcid or not, it makes no difference. If you're using somebody else's property, be that a vehicle, be it a room in a house, be it a house, bloody pay the people for it. First of all, don't expect all the rest of us to pay it for you, unless you're in genuine trouble, and then most of us are good to do that. Second of all, don't try weasel out of it by saying, well, you misspelled my name, so I don't have to pay for like a year's rent. But anyway, I did a little bit of digging to see if I could find out some more background. He did make a short video actually after this, explaining that the judge wasn't allowed to edit anything or whatever. It's pretty much unwatchable. But there was also some Facebook posts that I found very, very concerning. The first one, not so much. It says, the country makes money off our court date being broadcast live on YouTube. No, it doesn't. None of those videos, from my understanding, are monetized. So no, they don't. This is about providing it to the public the same as you would be able to walk into the back of a court and watch proceedings. And then there was the next one. It says, I'm done. I'm going public. I'm going underground. I'm going political. Fine. I can't read it out, so read the screen. The whole MF'er down, and then a link to the Department of Justice. So obviously that's quite concerning, and it has been reported. So anyway, folks, that's all we got time for. Just remember, if you struggle to pay your rent, all you have to do is claim sovereign immunity as a sovereign citizen, and oh wait, no, that's not going to work at all. So Jamal, let me say this to you. Get out of the other Jamal's house, because that guy owes a lot of rent, and he's going to get evicted. Obviously, I know that guy is you. You know that. Everybody knows that. But you, with your big smug head, really seem to think you're going to get away with it. Now, you might have seen a lady on the bottom of the screen earlier on in the video. There's a video up about her as well. Unbelievable. She claims everybody's racist, yada, yada, yada. Go check it out. It'll be linked in the description down below. We'll catch you in the next one, folks. Sláinte. Do you remember this quote-unquote guy? Pass me into Mr. Cunningham right now. We're losing this case. You need to stall him. Keep saying quote-unquote until I can get there.
I'm not supposed to be on U of L property. Is quote-unquote his quote-unquote quote-unquote, excuse me.
Well, anyway, I was scrolling through the old YouTubes, and in my recommended up popped a video from the old Squishy Gardener. And I couldn't believe it when I saw this guy's face again. And yes, he's quote-unquoting like the best of them. But before I start this video, I just want to give a massive shout out to Ken and William down in Passage. It was great to catch up with you today, and I hope you enjoy this video.
Yes, Council Cunningham here.
Your Honor, it's my understanding that Mr. Cunningham is representing himself, and as this is the start of a new proceeding, the people just ask that the defendant be advised of his rights to representation.
I'm advised of my rights to representation right now. I'm waiting for the subpoena to come back. So I was asking the court for a adjournment until the 31st or a little bit after the 31st of May, considering the subpoena has not came back. And nobody has not contacted me since I put the subpoena in. If y'all need a reference of basically when the subpoena was sent out, that would be, I can send that to you. And then also, as far as the original witness is not on the witness list, the accuser, quote unquote. And then also, Your Honor, I was supposed to ask for a motion for the case in whole with the videotapes and the transcripts, which still has not been sent out to me. So I'm also waiting for that as well, Your Honor.
Mr. Cunningham, it's generally considered to be a very bad idea to represent yourself. I want to advise you that if you do choose to represent yourself, that you're held to the same standards as an attorney. And as you know, attorneys go to school for years to learn how to do what they do. I won't be able to help you to
practice law, ma'am. You don't need
to follow the rules.
To practice law, you don't need to be a part of the bar association. Sorry, I already looked that up. Unless Mr. Lou Dang can show me a license, and I'm not talking about a bar license as well. I would dearly appreciate that as well. But yes, I rather represent myself, ma'am.
Okay.
I mean, if you want to show me a license,
what kind of
we can
license
go
are
all
you?
day. Actually, I'm talking about the practice law, ma'am. I'm talking about the practice law. You don't have to have a license to practice law. I mean,
yeah, sure. You don't necessarily need a license to quote unquote practice law. But what you're doing is not practicing law. What you're doing is Googling stuff and looking at memes and then claiming that's the law. You do, however, need an incredibly strong understanding of how all of this works to be able to be effective in court.
This is not the first time I've been in front of you.
I know that, sir. You said that you wanted to see a copy of Mr. Danner's license.
Okay. Well, you just kind of. I mean, I'm not taking it as a threat or anything, but you just stated it because he went to law school or whatever, that basically I still don't know my rights, ma'am. So one of my
Mr.
rights I'm
Cunningham?
asking is basically, yes, ma'am.
I'm required by law to advise you that it's a bad idea for you to represent yourself. I'm not doing it to
So is that
threaten you or
can I
intimidate
ask
you
a
or
question,
scare
ma'am?
you or anything else. I'm doing it because I'm required to.
Well, ma'am, I'm gonna ask this question then, ma'am. Is that advisement privately or commercially, ma'am? Is that advisement privately or
sorry?
commercially, ma'am?
I
Is
didn't
that
understand your question.
advisement privately or commercially? Are you advising me commercially or privately? You just stated it, advising.
I'm
ma'am.
advising you on the
advised me
record.
basically get attorney, man.
I'm
For
advising
the
you
record,
on the
ma'am.
record.
So would that be
What, sir?
privately? Would that be commercially, ma'am?
It's neither. It's on the record.
How is it neither on the record when basically it's a you're not my attorney, so how can you advise me to do anything?
There are lots of things.
It's a question, ma'am. It's a question, ma'am. I'm just asking, how can you advise me to do anything unless you're a representative, unless you some type of representative, have some type of contract with the Cunningham party? Let me know, ma'am. Unless other than that, you're an arbitrator.
Now let's see if the representative from the learned Cunningham party will allow the judge to answer the question that he has just asked.
Mr. Cunningham, every time that you appear in front of me when you're representing yourself, I'm going to give you the same advice, which is that you would be better served by having an attorney. I have to
Such
do
as
that.
the last three judges, ma'am.
Excuse me, sir.
Go ahead,
Sir,
ma'am.
give me a minute to talk. Every time you appear in front of me representing yourself, I'm going to advise you again that it's a bad idea. I'm going to advise you again that you'll be held to the same standard as an attorney. And I'm required to do that. If it becomes a problem for you that I advise you that you'd be better served by having an attorney, then we're not going to get along very well, sir. I'm doing what I am required to do by law, which is to advise you on the record that you would be better served by having an attorney. And I'm telling you right now, I'm going to do it every time that you appear.
Well, to get along, first of all, to get along and be in basically correct court proceedings and facts, it will be two different things, man.
Yeah, because the act of getting along actually exists in reality. Whatever it is you just said has no basis in reality whatsoever.
So to get along,
I didn't ask you anything, sir.
It sounded like a threat. Excuse me.
I did not ask you any
I just
questions.
listened to what you had to say, man. You're cutting me off. I just went through
Mr.
this with Ms. Perry, man. I was only stating my claim, man. I thought it was my turn to talk. If it's not my turn to talk, just let me know. I thought it was my turn to talk. If it's not, just let me know. But I thought it was my turn to talk. You just interrupted me.
What do you want to say to me, sir?
Well, maybe if you just shut your pie hole for 5 seconds and let her actually explain when it is your time to talk, she could actually do that. But no, the verbal diarrhea persists.
I just said what I was saying. I was trying to get a adjournment until May 31st until basically I get the information back from the subpoenas. And I'm actually basically Lou Dane, the attorney, to actually have the original witness, Calvin Kleinoff, on his witness list, man. That's all I'm asking. Other than that, I'm not asking anything else.
Your Honor,
Yes.
two things. First, if Mr. Cunningham would like an adjournment of this matter, I have no objection to Mr. Cunningham receiving an adjournment of this matter whatsoever. Secondly, the people are under no obligation whatsoever unless this matter is set for trial to produce any witness unless there is an evidentiary hearing in which there's a motion that is filed for an evidentiary hearing requesting the admission of an individual party who will be considered a res gestae witness to this matter. As there has been no articulation as such, and as Magistrate Garwood is not a party to the case, and also since Officer Kavanaugh, I believe in this case, would only be the officer who swore out the information, or in this case, or the complaint. In this case, that Mr. Cunningham, would you mind 1 second, sir? Would you mind 1 second? Thank you, sir. So, Your Honor, if Mr. Cunningham wants a trial to be able to exercise the court's authority of subpoena, then he can request a trial date and then try to have that occur. Or he can file the proper motion, as I am in receipt of a motion that is not the proper motion to be filed.
There's a surprise. The actual law expert received a motion from the non-law expert, which was completely in the wrong format and probably written with crayon, if he hadn't eaten them all already.
Nor is the relief that he is seeking such relief that this court would have the authority to grant. So it is my understanding that even if he wanted the adjournment or whatever subpoenas to go out or anything of that nature, that would be a non-starter, as that is not what would occur, as none of this was properly done according to the court rules or case law. So, but if he does want a trial, or if he wants, he can request a trial, and then he would be able to subpoena witnesses to be there to testify at a trial, as the court would fully advise him of that right. Beyond that, Your Honor, I am not in receipt of any intelligible motion in which he has stated any kind of claim in which this court could grant any relief.
Okay, we'll adjourn to May 31.
Excuse me, ma'am. I wasn't done talking, ma'am. If you look at first the document, A1 basically sent to the Cunningham party. What was it? October 26, 2020. Basically, you look at A1 evidence. Evidence. The states on there, Ryan Kavanaugh. He's not an officer. It just states that original witness. Now, the original witness, basically, we haven't had an motion for.
So this guy's arguing about why he doesn't need a lawyer. As I showed a minute ago, he didn't file the right motion. As if that wasn't bad enough, he doesn't even know that it's called a motion. He thinks it's called an emotion. If that's not a good enough reason for you to maybe take the free lawyer, then I don't know what else will be.
It's basically for the head of the case. I can't think of his name, Matthews. That basically, quote unquote, they tried to amend in that him to be the original witness, when basically the original witness was actually Ryan Kavanaugh, who basically is not a complaining officer, is not a officer. He was a regular civilian on the road. That basically they try to put in after the fact that basically I was not supposed to be on U of M territory, and then they searched my property, and then from there they try to add in Mr. Matthews as the original witness, when basically he cannot be the original witness if he's in charge of the case. That's kind of like a contradiction. And then at the same point in time, he did not sign up under a penalty of perjury as well.
Ah, Jesus. We got another one, lads. How many times do I have to hear the term penalty and purging Diddy, or Jeremy and Fergan Diddy, or whatever he's saying? Remember that guy the other day? I'll put a link in the description down below for those of you who didn't get it. He came up with about 8 different versions of penalty and purging Diddy, and literally none of them are even close. And if you're filing an emotion for penalty and purging Diddy, I don't think you're going to do really well without a lawyer.
So, I mean, I'm confused here, man. At this point in time.
You're confused at this point in time. You were born confused and you grew around it.
But I would take the adjournment to May 30, a little bit after May 31st, to find out if I can get the rest of my subpoena to go further and more than that. So if we can go to subpoena 31st, from there, my motion for a subpoena from there, I would gladly enlighten you about this case.
All right, were you asking for May 31st or another date?
I was asking just a little bit after May 31st will be much appealing over on my side, Mel.
Can anybody tell me, what does much appealing your aramasai mean?
Much appealing over on my side, Mel.
Is that some kind of freaky deaky soft-sit lingo that I don't know about? Well, that was an absolute clusterfuck. I have yet to come across a sovereign citizen that's actually genuinely intelligent, or that can actually understand what they're saying and pose a pretty solid argument. It's all just rambled mumbo jumbo. Anyway, folks, I hope you enjoyed the video. I had a lot of fun making it. Ken and William, absolute pleasure to meet you both today. I hope you really enjoyed this video. If you did, make sure and hit that like button down below, and we'll catch you all in the next one. Sláinte.